Thank you everyone for joining us today. I'm Seth Bloom. I'm Senior Director of Attorney Services at Level Set here in New Orleans. We're excited to produce another great webinar today with a construction lawyer down in Florida, and that's Adam Richards. He's out of Berger Singerman. He's a partner down there, and they have offices all over the state of Florida. And today he's going to talk about dispute resolution, tips for non-payment. So if you have any questions during the show, just go ahead and ask, or you can type them in, or you can always post them on our Attorney Network question and answers. So Adam, thank you so much for doing this today. We look forward to the presentation.
Thank you so much, Seth, and a special thanks to Level Set as well for putting this webinar together and hosting a host of other webinars on various construction-related issues, payment issues. Having these informative sessions where we can also have interactions, questions and answers. I cannot emphasize enough how important that is for the industry. What I've really tried to do personally, with respect to my practice and my clients, is, I'm fortunate enough to not only deal with construction in the transactional realm, the owner-contractor agreements, contractor-sub agreements, public-private projects, all different sizes at this point. But I also litigate the disputes, if it is in fact in court, even if it's an arbitration before the AAA, for example. I've litigated these disputes regarding non-payment from beginning to end on behalf of owners, contractors, subcontractors, design professionals, and through every single one of those cases and experiences, you learn what pitfalls occurred during the project, what issues in the contract, for example, were present throughout the litigation and the dispute. What language was problematic, what language should have been there that wasn't, or if an owner is interpreting a particular clause to mean something while the construction side interprets it to mean another. I believe it is so important as lawyers to give back to the community. And once we learn, the good, the bad, and the ugly through litigating any particular non-payment dispute, I believe it's only proper to pay it forward and to share with my clients and the industry at large what things we keep seeing case after case after case that are not being fixed by the industry. The contracts are not being modified despite these repeated issues, and laws that are on the books regarding contingent payment clauses, dispute resolution. If you have a bond on a job as opposed to a job without a bond, so that you would be enforcing lien rights, then you deal with waivers of bond rights or lien rights. The bottom line is it's such a minefield out there that if you are not constantly trying to be better from the development stages, the contract stages, the project management stage, and then of course the dispute resolution stage prior to litigation, you're only asking to repeat the same problems over and over and over again. So that's really what I want to focus on today. I want to give those practice tips, and I'll use some examples from recent cases as well, for you to deal with your non-payment disputes. Right? Just to give you a little bit more background of who I am and how I managed to become partner at Berger Singerman down in Miami. Actually started my career in the construction defect group of a large defense firm, also in Miami. And the construction defense world, for those that do not know, you're primarily dealing with claims of defects, you're dealing with catastrophic injury, wrongful death claims with respect to project site accidents, property damage claims, and then you have your third-party risk transfer subrogation type of claims. You're not seeing a lot of the non-payment world. You're not seeing the world regarding delays, bonds, liens, and so forth. And I recognized that very early on, and I just made it my business to join firms and always try to learn and develop those other areas. And since the defense time, that's exactly what I've done. I've represented national and international general contractors, subcontractors, design professionals in non-payment disputes, whether it's a bonded job, whether it's enforcing a lien, even if you don't have a lien and you didn't do what you have to do to be able to recover under the bond, doesn't mean that you don't have a contract action for non-payment. So non-payment takes many shapes and forms. At this point, I've seen those types of disputes on both sides of the aisle, whether it's representing ownership or the contractors, and that includes both on public and private projects. So like I said, at this point, I've seen enough to be able to share with you the most common pitfalls and the realities of non-payment disputes that, number one, I don't see often talked about, and number two, I also don't see lawyers talking about, let alone construction lawyers. And I just don't think we're serving the community if we're not sharing the information that we learn. So that's the background. We'll dive in now, and I think you'll get a sense for the practicality that I'm trying to impart here when you find yourself dealing with a payment dispute. All right, so the first thing that I want everyone on this webinar to know and understand is that contingent payment clauses, as far as I'm concerned, are a statutory / judicial creation by people that probably don't have a lot of experience in construction. And it's a lot of people, lawyers as well, that do not understand simply and purely the consequences of monies either slowing down or completely ceasing on a project. It is inevitable that there will be consequences to the lower tier subcontractors and suppliers. So in my humble opinion, rather than create massive statutory frameworks and rules regarding your contingent payment clauses to figure out if you have a pay when paid clause or a pay if paid clause, the bottom line is there's no reason why money should slow down or stop on a project if work is continuing and the job is continuing. That is the pressure point, and I think the industry has been a bit conditioned to work without being paid and to think that failure to receive money by an owner is just commonplace, and that a general contractor blaming a failure to receive money from an owner is okay, commonplace. You have a pay if paid clause, so be it. I think that has set the industry back probably 30 or 40 years as far as evolving and making sure that on a project, if the work is continuing, the monies are flowing because those contracts and our laws provide an endless number of remedies to deal with issues separate and apart from having to cut off funding and then just creating additional issues as a result of cutting off those funds. It simply makes no sense to me. Now, of course, there's exceptions. There's things that can happen on a job that may require some type of a drastic action, but those are few and far between, I promise you. To explain what a contingent payment clause is for those that don't have too much familiarity, it's primarily a contractual provision that states as a lower tier subcontractor or supplier when payment will be due from your general contractor. Now, the industry commonly refers to these as either pay if paid or pay when paid clauses. But the first thing that you have to understand is that the enforcement of contingent payment clauses is totally and completely dependent upon your state law. All right. Just for an example, Florida is one of those states that they treat them in a hybrid fashion. And let me explain. So Florida's policy in general is that the state does not like contingent payment clauses. The state does not want to foster work being performed, subcontractors and suppliers being squeezed, as long as an owner is failing to pay the general contractor, right? So they don't like giving a general contractor the ability to rely upon those contingent payment clauses. Said another way. However, Florida, even though they don't like it, they won't go as far as to strike down a contingent payment clause. Instead, what Florida has done, for example, is it's through a variety of cases, it's narrowed and specified what language you need in your contingent payment clause in order to be able to enforce it, right? And to give you more details to close the loop for everyone, in Florida, for example, the language in your contingent payment clause must make it expressly clear that the lower tier sub or supplier is going to bear the risk of the owner's non-payment, and that the owner's payment is a condition precedent to payment flowing down from the general contractor to those lower tiers. If you sign a contract that does not have that language, even if it says something close to it, or even if the contractor interprets it as an enforceable pay when paid clause, when that provision is before the courts, the court will not enforce it as a pay if paid clause. Instead, the courts will simply apply the reasonable time standard to that contract agreement, which means the contractor now has to make those payments simply within a reasonable time to the lower tier subs and suppliers. And the reasonable time has nothing to do with the owner's payment or lack thereof. Now, some savvy construction lawyers, what have I seen already as a result of that case law? I've seen contracts from a GC that will literally say, if this clause is struck down, the parties acknowledge and agree that a reasonable time shall be the time it takes for the owner to make payment or for the general contractor to obtain payment from the owner through judicial means or through enforcement. So I believe that language will still fly in the face of the policy, will probably get struck down if it's ever challenged in front of the courts. But the first hurdle for everyone to understand, and I cannot reiterate this enough, is you need the right language in your contingent payment clause for enforcement. If you do not have that right language, those trigger words, so to say, you are dealing with a provision that you may not be able to enforce in a court of law. Now, it may be able to convince a party of something before you get to the courts, but we also want to know what we're dealing with in the event this does escalate and come to a head. Like I said, even before you get to the enforcement of your clause, the first step is to determine in your particular state whether or not the clause can be enforced, right? Whether it's certain language that's necessary, or for example, in California, it doesn't matter what language you use or how clear you try to make the condition of the owner's payment. California says we do not like contingent payment clauses. Therefore, the general contractor has to make its payments to the lower tier subcontractors and suppliers. So number one, state specific. Number two, if your state does allow enforcement, you need to understand what's required for enforcement. All right. Number three, looking at the slide, is the prime contract importance. And this is a step that I see general contractors and lower tier subcontractors and suppliers overlook 99 out of 100 times. Let me give you an example from Florida. One of the most prevalent cases regarding contingent payment clauses is known as the OBS versus PACE case. Now, if you read that case, my interpretation is yes, there is a means to enforce a contingent payment clause with the proper language. But what does PACE also stand for? PACE says that even if you have an enforceable contingent payment clause, that clause better not contradict or create an ambiguity with any other payment clauses in the contract documents. Right? That right there is huge. And this is why, and I've seen it on both sides of the aisle at this point. Let's assume your state allows enforcement of your contingent payment clause. Step one, complete. Let's assume your clause includes the proper language in order to be enforced by a court of law. Step two, checked. Step three, are there any other clauses in your subcontract or in the prime contract documents that may lessen or contradict or even raise an ambiguity with respect to your contingent payment clause? And I'm willing to bet you that there more times than not, your prime contract documents will be contrary to your subcontract's contingent payment clause. Let me say that again, because it's very important, and this is a complex topic. As an owner, when you're dealing with your general contractor, do you think you would want your general contractor being able to not pay the subs and suppliers unless, as the owner, you're paying your general contractor? The answer is no. As an owner, you're going to want your contractor to still have to pay your subcontractors and the general contractors, subcontractors, and suppliers, regardless of a dispute. You know, if an owner makes a partial payment or starts withholding payments because of damages, indemnity claims, allegations of defective work, for example, the contract may give the owner every right to do that. So funds will not be flowing down to the general contractor, and yet the general contractor is either going to withhold those funds from the subs or pay those funds. As an owner, you're going to want the GC paying those funds, and as a result, you're going to make sure that your prime contract documents do not allow for a contingent payment clause. Most likely, your prime contract documents state that in exchange for a progress payment to your general contractor, your general contractor will give you releases of lien from your subs and suppliers, right? Those releases of lien represent that the subs and suppliers are paid in full. No outstanding payments for all work completed.
Adam, I just wanted to interrupt for a second. We've had a pretty quiet room out there, so I just wanted to encourage everyone again Adam's an expensive lawyer, so if you have any questions, go ahead and post them right now, ask them, and we can get some answers. And we'll hold a few minutes towards the end for that. But Adam, sorry about the interruption. Just want to see if anyone out there was being shy.
Not a problem, Seth, and I will I'll echo those words. Please, I have no problem being interrupted, at least during this webinar, because if something comes to mind, I don't want you to forget it, or at least write it down so we can talk about it towards the end. The bottom line again with respect to these contingent payment clauses is there's a very strong chance that the prime contract documents are going to contradict the subcontracts, because the prime contract documents are going to require payments to your lower tier subcontractors and suppliers. That means even if you have an enforceable contingent payment clause as a GC, if anyone can point to the ambiguity being raised by the prime contract as not allowing for a true pay if paid clause, then that ambiguity can also serve to invalidate your contingent payment clause, which again is going to require payment in a reasonable time. So if you're a subcontractor or a supplier and you have any type of a payment dispute, right, 9 times out of 10, you will likely think, oh crap, I have a pay if paid clause. Oh crap, my general contractor told me that the owner hasn't made payment. But legally, you have to understand that enforcement of a contingent payment clause through the courts is extremely difficult. It's either going to be outright prohibited, it's going to be limited, or even if it's limited, but you can get away with it, there's probably going to be an ambiguity in the prime contract documents.
Adam, we had Nicole asked, and I know you partly answered this, are there any differences specifically for written contracts signed versus electronic contracts? How to properly convert and estimate to a contract? What would those requirements be?
No, I would not say there's differences between your written hard copy agreements and your electronic agreements. The bottom line, Nicole, is you need to have the proper terms and conditions regarding the schedule, your payments, your dispute resolution, insurance, indemnity, all of those big ticket items, whether you're fully electronic or you're still dealing with hard copy agreements. The most important aspect is making sure that the terms within those documents are protective, are enforceable, and are forward thinking. And that's certainly going to be the most important aspect for us. So as far as, if you're a general contractor and you're saying to yourself, oh crap, what does that mean? Does that mean this pay if paid provision I thought I could rely upon, I now cannot rely upon, such that I will continue to have to make these payments to my lower tiers, even if the owner's payments are either slowing down or have completely ceased? And the answer is no. I just gave you the framework to understand what you will need as a general contractor to be able to enforce and rely upon your contingent payment clauses. One of the greatest difficulties you will have as a general contractor is trying to close the loop with the ambiguity in the prime contract documents, because essentially what we're saying is, as a GC, you need to explain to the owner, I need your payments. If I'm not getting your payments, I'm not paying my subs and suppliers. And chances are an owner is not going to be okay with that, just in terms of negotiation and leverage during the early negotiations. But if you can have that discussion, if you can broach the topic, if you can explain what the reasons to stop funding may be, possibly with more specifics, or at least to withhold funds, and you can cross the bridge of reaching an understanding that funds need to be paid so that funds will be released to the lower tiers with ownership. That's the golden gun right there. Then with confidence you can say, for your particular project, we have a pay if paid provision. The subs and suppliers will be bound to it, and the owner understands it. But we all know, I'm sure every single person on this webinar knows and would agree, that rarely are negotiations had during the contract stages to get into that much detail and really try to create an environment for success with respect to continuous funding from inception through completion. All right, that's why I included the prime contract importance note on this tab, because I cannot overstate how important that analysis is when you're either asking yourself, do you have an enforceable payment clause, both before dispute and if the dispute is escalating. That brings me to the next topic, dispute resolution. This is really just a few practice tips and pointers that I've seen trending because of the reality that I just explained regarding these contingent payment clauses. I'm confident that 99% of these participants do not know what a liquidating agreement is. A liquidating agreement is rarely used still, even today, even amongst your national and international general contractors. What it is essentially a dispute resolution mechanism to deal with the reality of payment problems on a project for a general contractor. Right now, if funds cease to a general contractor and the general contractor therefore is unable to make payments to its subcontractors and suppliers, a very common situation, as we all know, there's dominoes that will inevitably fall, right? Those subcontractors, those suppliers, probably the general contractor as well. If it's a bonded job, they're going to be seeking recovery under the bond for non-payment. If it's a job without a bond, then they will be moving to enforce their lien rights. Right now, if you have a large project, for example, couple of projects that I've been a part of the last couple of years, the Panorama Tower in Brickell, Miami for $300+ million, the Broward County Courthouse up in Fort Lauderdale, hundreds of millions of dollars. If you have non-payment problems, inevitably you will have more issues with your lower tier subs and suppliers. And then those lower tier subs and suppliers claims create even more of a headache between the general contractor and owner, because the general contractor and owner may be joined in those claims and lawsuits. So the liquidating agreement is essentially a means to stop that domino effect from happening. What it does essentially is it says, if you're a lower tier sub or supplier and you are unpaid, and that non-payment relates to the owner's failure to pay, you will allow the general contractor to resolve your claim on the sub or supplier's behalf. And if you file, yes.
Sorry, I didn't want to interrupt, but Donna came in with a question.
Sure.
If we have an AOB Florida, we cannot take a client to court for not payment since it's prohibited. Question, is this correct?
The AOB, so I believe Don is referring to the assignment of benefits, which is a little bit different than what we're talking about. That's if you're dealing with a possible insurance claim and the contractor does work for an assignment of the owner's rights and benefits to the insurance policy, and then the contractor essentially is allowed to go after the insurance policy to recover the costs of said work.
Is that or arbitration? I wasn't sure either.
Yes, yeah, exactly, Seth. So I'm not sure, because the bottom line is the funds do not flow from the owner typically. That's the whole purpose of the AOB, that the contractor will be looking to the insurance company to make that payment. So I don't know if that clarity helps, Danya, but feel free to ask us if you have any additional questions, or if that didn't answer exactly what you're looking for. So back to the liquidating agreement, it's simply something that you need to keep a lookout for, because it not only deals with the contingent payment clause, it actually deals with what your rights will be and how your rights may be extremely limited in the event of a non-payment claim that's emanating from the owner's non-payment. Those liquidating agreements can be enforced. They will be enforced. And if you sign an agreement that has a liquidating agreement, you simply need to understand the realities of non-payment and whether or not you even have a claim to pursue, or if you've already assigned that claim to your general contractor to pursue on your behalf. And that's whether you have an enforceable contingent payment clause or not. So liquidating agreements are certainly trending, and I just want to give everyone a heads up on their use. They're very often used already in your federal government jobs, and I'm already seeing them being used more and more on your private jobs, but just because of the reality of trying to bring some order to a non-payment project where you can have dozens and dozens of consequential lower tier claims and lawsuits. That also deals with the forum where your dispute is. And of course, I also added notices because you have to keep in mind, if you are going to have a non-payment claim, whether it's a lien, whether it's a bond, there's notices that you have to follow both statutorily and under your contract. And again, if you are starting a job and you already do not have a process where you've identified those notices, those requirements, and you already have somebody or some department responsible for dealing with those notices, you are behind the eight ball. You need to evolve immediately, quite frankly. Bonded job, I know we're running out of time, so I'll be able to run through this pretty quickly. The note there, really, the practicality is if you have a bonded job, your non-payment issue should largely be related to recovery under the bond. You're not going to be dealing with liens, unless, of course, you have a conditional bond, which is a Florida statutory creation that, again, is rarely used because an owner simply says, I will not allow a conditional payment bond on my job, which is a bond only to the extent of the owner's payment. So even though it's there, it's rarely used, and you're only going to have your typical bonds without the conditions, which means you cannot rely upon a contingent payment clause to deny recovery under a bond. So again, another reality that flies in the face of the concept and policy behind contingent payment clauses. All right, to finalize today's discussion, I want to also mention, of course, the reality of dealing with private and public prompt payment laws. Florida, for example, has an abundance of private and prompt payment laws on the books. Those laws provide the timeframes for both public and private projects where certain payments do need to be made after receiving a proper and legitimate payment request. And then, of course, those laws also provide for certain interest penalties in the event that payments are not being made timely. So it's great to know the laws. It's great to understand the laws. For example, Florida's private prompt payment law even allows an expedited cause of action, in the event you are not paid and certain other requirements are made. But, I can only emphasize that relying upon these laws only gets you so far because you still are going to seek enforcement, and you need some type of a lawsuit or claim to do that. So again, if we're already looking to the non-payment law to govern where you stand, we've probably already, missed the boat. You should not have to seek escalation that far down the road if we're dealing with this properly from inception, from the contract stage, the project stages, and then, of course, even if there's a claim or a dispute. So that's what I want to reemphasize to close. Everyone has payment problems. Everyone has dispute resolution nightmares. But the bottom line is there's a host of resources out there just because of the reality of these projects to deal with these problems ahead of time, build the proverbial cocoon around your companies, and don't find yourself having to be in a lawsuit over non-payment because there's so many resources you have to prevent that escalation. All right, so if there's any questions, concerns now, or even going forward that should come up, always happy to chat, always available. It was a pleasure.
Yeah, Adam, thank you so much. And I don't see any more questions right now, but we did get a few during the webinar. Although, wait, we've got one more. I'll be real quick because we're running quite a bit over. But Donna asks, what's good with a lien? What's good with a lien to do if the homeowner's reasoning is I'm not going to sell my house, so I don't need to worry about it? I guess they're saying, what's the use of the lien if the person's not going to sell the house?
I got it. It's a great question, Donna. The use of the lien is twofold, right? Even in the absence of a sale, right, the lien is still an encumbrance on the property, right? So, the lien can obviously create some problems if there's anyone doing a search in the public records, in connection with a potential acquisition down the road. But at the same time, right, it's not about selling the house, right? The purpose of the lien is primarily forcing a sale of the house, right? Let me say that again, Donna. When you file a lien on a property, and that property, it's a legitimate lien, it's an enforceable lien, and you win your lien foreclosure action, that's a forced foreclosure of your lien by the courts in order to get you paid. So it's not up to the homeowner whether or not he or she plans on selling the house ever and may have a problem if there's a lien on the property. It's if you have a lien, you're going to have a short time frame. In Florida, it's a year to foreclose your lien. And the foreclosure of a lien is essentially a forced sale of the house. Now, depending on the value of the lien, you may not actually end up selling the house because it's only about the value that we need to obtain. But if you have a lien that's going to be sizable or possibly comparable to the value of a home, that will be a big problem for a homeowner. So I encourage you to understand it's not about the homeowner's desires really at all. It's about what the ability to lien a property means for contractors.
Well, Adam, that's been really helpful. And if anyone has any other questions out there, they can contact Adam directly. We'll also make these slides available both at his website and at ours. Again, I'm Seth Bloom. I'm Senior Director of Attorney Services. If there's any other questions from this webinar or you generally have construction questions anywhere in the U.S., post them on our Attorney Network question and answers, and an attorney like Adam can answer them for you. Obviously, Adam can handle anything in Florida, so give him a ring or ask the question and see if he'll answer it on our Q&A. But thanks so much for joining us, and we really appreciate it. Have a nice day. Thanks, Adam.
Thank you. Thanks.